Are you an adjustment of status green card application applicant and you may have an arrest, or maybe you got arrested and you think you weren't convicted, or you are 245I, you've entered without inspection, so you entered without admission, a visa, but a petition was filed for you with a priority date of April 30th, 2001, priority date that predates that date, April 30th, 2001, or maybe a labor certification. Well, I had 2 interviews this week with 2 different applications. One of them was from a couple of days ago, and it was an elderly lady who was a victim of domestic violence and had been arrested for stealing basically some food to feed her hungry children. And she believed that even though she was arrested, she went to court and the case was dismissed. However, so one of the biggest things you want to do in those cases is get a background check. Don't just, trust what the client thinks happened. So in this case, they hadn't done a background check because this was something that she was very adamant about it, and it was for another attorney that I was covering. But basically, if had they done a background check, it would have prevented what happened during the interview. And what happened during the interview was that basically the officer was like, "Are you sure you weren't convicted? You don't remember this court in such and such city?" And she goes, "Yeah, I remember that court." And she was elderly, so this was from 20 years ago. So her memory was like, not that great about what happened 20 years ago. And, she probably was traumatized from the domestic violence that had occurred and the fact that she was having to steal food to feed her hungry children. And, it was a sad and sympathetic situation. So the officer was nice about it, but he kept asking her, like, "Are you sure you weren't convicted? Did you not serve probation?" And she kept going, no. And that's when I intervened and I said, "Hey, like, officer, is there something you have there? Like, maybe she's not remembering." And he was upfront, and he was like, "Yeah, look, we have something here that shows that she was convicted, that she was punished, she was put on probation." And so, I was able to confront the applicant about that in a nice way and say, "Hey, look, it's apparent that you think that you weren't convicted. You're admitting, obviously, that you were arrested, but, you don't know what happened at court. Maybe, it seems like you were put on probation. So it's better we change this answer." Now, I'm glad we did that, because if she would have kept going down the pathway of denying this arrest, or the conviction, and being punished by a judge, which are 2 separate questions on the 485 form. One is like, have you ever been convicted, separate from just being arrested? And another one is, have you ever been punished by a judge? And so she should have had both those answers as yes, and she had them as no. So we needed to make that change, because if she hadn't made that change and she kept going down that pathway, she would have had her application denied for committing potentially a misrepresentation for trying to obtain an immigration benefit. And so that was a great, basically change that we were able to make for her. But the point of this is that, you really want to make sure we do fingerprints and background checks for anybody that we think has any kind of arrest. And so it's important that you do that, so that, we get the accurate information. But fortunately, this was something minor. It was for petty theft. Petty theft doesn't even make you ineligible to adjust status. It's just, you just need to make sure you got the accurate information. Now, another one that I just walked out over here behind me, this is the federal building in downtown Los Angeles as well, is that this applicant was for 245I, so that he had entered without inspection, actually one time, and then another couple of times he had been detained. But luckily the Border Patrol had not expeditedly removed him. They didn't give him any documents. They just basically turned him around. This was way back in 1990s, and so this is often what happened back then, is you just got caught and you got turned around. Sometimes they processed you, and most times they didn't. And so the fact that he basically was turned around, wasn't issued an expedited removal, he had a petition by a sibling that had a priority date of April 30th, 2001. He was able to basically now use his United States citizen daughter's petition for him, who's now above 21 years old, and now he was able to adjust status. And so that was a good victory. It was helpful to have a good officer as well. So just keep in mind, if you entered without inspection, you can't adjust status here in the United States typically. You must have been admitted or paroled with some kind of visa or parole. But if you do have a petition or labor certification that has a priority date that predates April 30th of 2001, then you may be able to adjust status while remaining in the United States. I'll of course consult with an attorney if any of these cases apply to you. If you need any help with any kind of green card applications, adjustment of status applications, you can reach out to me at rodarmandelaw.com. Take care and have a nice day.